I am not Steve Sussman. Unfortunately, he is not able to join us this afternoon. My name is Richard Jolly. I work as the research fellow for the NYU Civil Jury Project. I'm an attorney in the state of California. I currently am in New York, and I will soon be joining the firm of Sussman Godfrey, so I make my way to Houston not infrequently. If you don't know what the Civil Jury Project is, it's the nation's only academic institute dedicated to studying the decline of civil juries and also methods and innovations to make the institution better. For that reason, we've been putting on jury improvement lunches like this around the country. This is our 15th jury improvement lunch overall. I believe it is our 4th here in Houston. But this particular jury improvement lunch is exciting for us, as it is correlates with Jury Appreciation Week here in Texas. If you don't know what Jury Appreciation Week, you might not be alone. This is actually only the 3rd Jury Appreciation Week that Texas has held. It was created by the 84th Legislature of Texas in 2016 to coincide with Law Day, which was actually created by Dwight Eisenhower back in 1958 to celebrate the role that law plays in our society and in the continuing viability of our republic. So Jury Appreciation Week is not also just celebrated here in Texas. Many states are starting to hold these celebrations of what the jury brings to our judiciary. And that's why we are so excited to have it here today. In fact, just yesterday we held a lunch in Dallas. I wasn't there, but I was told it went quite well. So one of the reasons why the Civil Jury Project was founded was to study the decline in the overall number of jury trials. And I'd like to direct your attention to this chart, which shows the federal courts, the percentage of civil terminations by bench and jury trials from 1962 to 2017. The numbers prior to 1962 show a similar trend. Unfortunately, they're not as reliable. It was 1962 that they started being kept reliably. You'll see that in 1962, roughly 58% of cases filed were disposed by jury trials. And in 1987 and 1988, it shifted such that there are actually fewer bench trials today than jury trials, which indicates something more systemic than just those criticisms lobbed at the jury as an institution. Today, the number hovers, as you can see, around 0.7 to 0.8%. That's 0.7 to 0.8% of all cases filed are disposed of by civil jury. Another way to look at those statistics is by the number of civil jury and bench trials per authorized judgeship. So this is the average number of trials that a federal judge will try in a year. In 1962, you'll see that number was around 10 jury trials. Today, it's around 2. And note also that figure doesn't account for the work of senior judges or of temporary judgeships. This is only the account of authorized judgeships. So that's remarkable. That is remarkable. This is also going on here in the Southern District of Texas. This is the number of jury trials and bench trials right here. Just last year, there were 45 jury trials, meaning that there were 2.37 per authorized judgeship, which is above average. So that's good. There are some places, some district courts in the country that have literally tried 0 jury trials last year. Unfortunately, I do not have the state court data from Texas, but I can tell you that in all of the jurisdictions that we've studied here at the Civil Jury Project, the trend is the same, and that also goes for the National Center for State Courts, which is more dedicated to keeping track of state court data. So there are certainly more trials, jury trials, bench and jury trials happening at state court, but it's lower than it's ever been. So if you've come to one of these events in the past, these numbers won't surprise you. If you've been practicing law for the past couple of decades, these numbers might not surprise you. But after I've held a couple of these events, a lot of the feedback I've been getting is people wanting to know more about what's causing this decline. And usually we don't dedicate too much attention to this, but I want to. And it's continuing learning education, so you need to learn something. I don't want it to be a history lesson, but really these numbers start to fall around 1938 with the adoption of the Federal Rules of Civil Procedure. That is when the joinder of our courts of law and courts of equity came together. And it used to be that the only way you could even get a bench trial is if you went to courts of equity. There was no such thing as a bench trial for a common law claim. And that started to change with the Field Code, which was first passed in NYU, in New York, where they started saying, no, we're going to join our courts of law and equity. A few states followed suit, and pretty soon it caught on at the federal level, and the advisory committee was formed to help propagate these new federal rules of civil procedure. One of the things to remember, though, is that at the same time, there was a brewing of anti-democratic sentiment, not just here in the United States, but all over the world. And a lot of the advisory committee that actually propagated the Federal Rules of Civil Procedure were pro-judge, if not anti-jury in their thinking. Very adamantly in their writing, I might add. So for instance, Charles E. Clark, you might remember his name from your law school classes, he disparaged the jury as the town hall method of trying cases. He claimed that it injected an element of rigidity of arbitrary right into a system wherein general rules of convenience should prevail. I like this term arbitrary right because that differs very, very much so from what the Founding Fathers thought. That arbitrary right actually almost made it so that we didn't even have a constitution. It was after the Constitution was first put forward and it went out to the ratifying states, the number one complaint coming back was, where are our civil jury protections? This was the number one thing that they wanted added. There were other protections as well, but the most common refrain was civil jury protections. And in fact, Massachusetts conditioned ratification upon the addition of the Seventh Amendment. So Charles Clark's claim that it's an injection of arbitrary right is quite curious. But I'll move on. James Fleming, another one of the advisory committee members, this is what he wrote. He whittled the core objectives of the Federal Rules of Civil Procedure down to just 3. And the second one read, the right of jury trial should not be expanded. This method of settling disputes is expensive, dilatory, perhaps anachronistic. That's quite exciting here on Jury Appreciation Week. One of the ways that they chose to undermine the jury was by adopting Federal Rule of Civil Procedure 38. And those of you who practice in the federal courts, and I believe here in Texas as well, that's the rule that requires you to claim your jury trial right, or it's waived. That is, if you do not say, I prefer a jury trial over a bench trial, you don't get your jury trial. That was not at all the case. As I just mentioned, you couldn't even have bench trials at common law. In 1941, another scholar writing about the adoption of Federal Rule 38 wrote, the most effective device yet evolved for effectuating a more limited use of the jury and yet preserves the constitutional right is that of requiring the party to make a timely demand or be deemed to have waived his right. So this is just one of the ways that they actively tried to limit jury trials. But there are other effects that the Federal Rules of Civil Procedure brought in that are less deliberate, but that equally have brought the number of jury trials down. The biggest one is, of course, pretrial discovery. Prior to the Federal Rules of Civil Procedure, there wasn't really a system of discovery. In courts of equity, there were limited things that we would think of as discovery, but it was almost completely absent in courts of law, which meant the only way you could learn about your case or your opponent's case was through going to trial. Now that we have this system of pretrial discovery, it makes trials unnecessary. Because if I already know all of the information, there's no reason for me to go risk it all at trial. Moreover, in the past 100 years, we've had dramatic advancements in the preservation of evidence, which means, again, less need to go to trial. And so there are legitimate reasons why we would have fewer trials today. In fact, Justice Gorsuch recently said, we used to have trial without discovery, now we have discovery without trial. Another effect that the Federal Rules of Civil Procedure had was by allowing for the liberal joinder of parties and claims, you needed judges who were able to administer that system. And the rise of administrative judging came not too long after the Federal Rules of Civil Procedure. In the 1960s, the judiciary abandoned master calendars and moved to a system of individual assignment, which allowed judges to shepherd cases from filing to disposition. At the time, they also issued a handbook that informed judges that they should try to help settle cases. That, of course, was brought into in 1983 in the revisions to Federal Rule of Civil Procedure 16 that judges should try to, quote, facilitate settlement as a core objective of pretrial conferencing. And so this role of the judges taking on a more active role, and from talking to lawyers around the country, they're quite quick to suggest that one of the reasons why trials are down is because of judges. I'll add that judges think it's the fact that the attorneys are risk adverse. But regardless, this newfound role for judges has further played a role in the decline of jury trials. You can actually, I'll go back, I'll leave it on this one just so you guys can follow I'm almost done with the history, but you can follow some of the fallings there. Of course, 1984, 3 years later, you had the summary judgment trilogy in which the Supreme Court dramatically expanded Rule 56, claiming that no genuine dispute of material fact existed. Judges could then dismiss a case. Note that before that trilogy, summary judgment was referred to as a toothless tiger and was used sparingly. And if for those of you, myself included, who didn't practice prior to 1986, that's mind-boggling, that that's actually at one point was referred to as a toothless tiger. And post-trilogy, you have a statistically significant increase in the number of summary judgment motions made, the frequency with which such motions were granted, and the rate at which they were affirmed on appeal. The last bit that I'll add is that our judges are quite overworked. The last time that Congress got together and actually created new federal judgeships was in 1990. That's the longest period Congress has ever gone without adding a substantial number of judgeships. In fact, a Northwestern professor and Stephen Calabrese recently argued that for Congress to keep up with the caseload advancements, they would need to create 68 new district courtships. 68. That is a remarkable figure. Now, I'll note that a lot of these I've been talking about is the federal courts. Some of these have bled over to the, my apologies. In 1984, the Supreme Court also said that arbitration, the Federal Arbitration Act was a national policy and that preempted state law. And that's the point. That's where we start seeing the way that it bleeds into state courts. And also there's a cultural shift. There's a change not just in the way judges view themselves as shepherding cases, but in the way lawyers view themselves in settling disputes and bringing efficient resolutions without the need of either our public courts, our public, in the term of the jury, or perhaps they prefer to go towards private dispute resolution, which of course is one of the core competitor to public dispute resolution. So it's important to realize how these all interrelate to cause the decline that we're seeing. This is quite remarkable to in 100 years go from the only way you can resolve your common law dispute is with a jury to your shrink-wrapped contracts. That's a pretty big shift. So what can be done about this? Well, the Civil Jury Project is trying to do something. We are trying to expand the dialogue, which is one of the reasons why we're here today. And we do so with this website, which we direct to our judges and practitioners. Here we keep a clearinghouse of information. We have research papers. We have scholarly resources. We have videos here also of all of our events. And it also keeps copies of our monthly newsletter, which we send out promptly. In fact, there should be one that went out yesterday. Which keeps people engaged and keeps this dialogue going. Because if we don't keep this dialogue going, we will lose juries. They will continue to be relegated to the past, as what happened in England. England used to have civil juries as well. In fact, that's where we got them from. And since World War I, they have dramatically curbed the rights so that it only applies in a very limited number of civil law cases. Libel, defamation, and I think kidnapping, which is kind of weird, but I'm pretty sure those are the three. So we keep this website. And then this website is what we have for all of our, this is our public-facing website, which we maintain for citizens to come learn more about the jury system and their Seventh Amendment rights. You'll note that it's divided into 3 core channels. On the far left, we have received a jury summons. Excuse me. We actually get quite a few people clicking on this one. It's the most commonly clicked on link on our website. And most people, we believe, are clicking on it to try to figure out how to get out of jury duty. We know this because the Google ads that we run load our website when people type in how to get out of jury duty. The next step is currently serving on jury duty. When you click on that link, it says you should not be here. The judge told you do not go do research while you're on a jury. And our final one is served on jury duty before, where we allow people to submit their stories, to tell us what they thought of the experience. And ultimately, through that third link, we collect testimonials from jurors who have served, and we put them back in the first link so that people who are looking to get out of jury duty can hear from people who have served that says, actually, jury duty is a fantastic experience. It's actually very rewarding, because a lot of people don't realize that while it may take some time out of your day, it's actually, most people who serve actually have resoundingly positive things to say. The way we get people to this website is through these business cards, which we ask our judicial advisors to pass out to jurors after they have served. I'm not sure if some of our jurors today actually might have received this card. And another way we do it is through social media. And we maintain a Twitter and a Facebook page. Our Twitter page is growing constantly. I think we're up to nearly 2,000 followers at this point. And our website maintains 500 people visit the website every week. So that's pretty good. Now, I'm not sure what type of difference the Civil Jury Project is making on some of these softer side of things. But we do recognize today that there have been in the last year quite dramatic public understandings of the civil jury. I think that the Me Too movement is actually a really great example of it, as there's been a broader and public discussion about the use of arbitration clauses in employment contracts and the way that they've been used to silence women and other victims of sexual abuse in the employment context. So much so is this becoming more public that Gretchen Carlson, who formerly used to be a news anchor on Fox News, she's a huge champion of this issue and was featured on Time Magazine, on the cover of Time Magazine, 8 months ago, or maybe a year ago at this point. So we're having this bigger discussion. And our profession isn't to be left out. In fact, just about a month ago, Munger Tolles, a law firm that has offices in San Francisco and Los Angeles, it became known that they were requiring their summer associates to sign arbitration clauses in their employment contracts. And there was an immediate backlash on Twitter that resulted in not only Munger Tolles removing it from their contracts, not just for summer associates, but for associates as well, but other law firms also. And so there is, I would love to say the Civil Jury Project is responsible for these things. I'm not positive that we are, but it's important to realize that there is this broader discussion happening about what the Seventh Amendment means, what it means to be able to air your grievances before first of all, just a public dispute resolution venue, but also before your peers. And but one area where I think the Civil Jury Project has been making more concrete advancements is in our proposals of innovations. We've been saying that the most common, while all of these shifts in case law and the availability of private dispute resolution is, we're not going to change that for the most part. But what we can change is the idea that the jury is not very good at what it's supposed to be. It's expensive. It takes too long. The people get the answer wrong. And that means that we need to look at the jury as a way to improve it, as a way of saying, no, actually, we can make it more effective, we can make it more efficient, and we can make it more accurate. And so we've been studying a list of innovations, some of which we'll talk about today. But I'll name off just a few of them. These were proposed by scholars and judges early in the 1980s in Arizona, actually, and studied at length. One of the most frequently cited jury scholars actually studied the preliminary use of these innovations in Arizona. Her name's Sherry Diamond. So one of them is limiting the lengths of trials. It's important that trials don't go on and on. That drives up cost. It wastes people's time. Another one is the use of preliminary substantive instructions. It's one of the only areas, jury duty is one of the only areas where we say, okay, we're not going to tell you how to put this thing together until the very end. Usually in a classroom, we say, no, here's sort of what you need to do, and we'll reframe it at the end after the trial goes on. So that's another innovation that we've been playing with. Juror-posed questions, allowing jurors to ask witness questions. Using extensive pre-voir dire questionnaires so that we can get more information up front and ensure that the jurors who are on paneled are good and are more likely to decide the case impartially. Using opening statements before voir dire, interim arguments by counsel, back-to-back expert testimony, which in Australia is known as Australian hot tubbing, and I have no idea why. and allowing jurors to discuss the evidence before final deliberation, which might sound like sacrilege, but Arizona has been doing that for a very long time, and the studies have shown that the jurors do not make up their minds prior to final deliberations. They heed those instructions. And a lot of these innovations that we've been recommending, some of our judicial advisors, of which we now have 250 around the country, a little bit more than 250 around the country, they've been experimenting with some of these with great effect. Some of them they don't like, some of them do like. We've been getting feedback from attorneys who have practiced with some of these innovations. And it's an interesting way to further talk about how the jury can be made better. But one of the more difficult things is for us to actually talk to jurors who are a core part of the institution. We need to ask them how the jury can be made better. And that's what these events are all about. We invite jurors here to talk with us, to talk to the bench, to talk to the bar about what they think can be changed to make the institution better and more efficient and effective, and empower them to make the types of decisions that our entire judiciary depends upon. So that's what we're here for today. And before I invite the jurors up on stage, I want to thank the judges who are here today, because we couldn't put on this event without our judges. So I'm going to read them off, and then if they could stand. We have Judge Baker, Judge Costa, Judge Englehart, Judge Hawkins, Judge Landrum, Judge Schaefer, Judge Villarreal, and Judge Hind. And if we could, thank you. And now I'd like to invite the jurors. And I think you all have a microphone in front of you, and they should be turned on. Great. So thank you so much for joining us. If I remember correctly, all of you served on a civil case in state court. Is that correct? Had any of you ever served on a federal jury before? Was this your first time serving on a jury? So we have a couple of first times and a couple of first times. Okay. Second time. So let me ask people who have the first time that they served on the jury. How did you feel when you first got the summons? Were you excited? Were you dreading it? Did you go online to try to find a way to get out of it? Mr. Maine.
Well, I was dreading it
Hold
at
the-
first. Oh, sorry. I was dreading, just like he said, but I knew it was my duty, so I didn't try and get out of it. I just decided that I was going to do it and do it well.
Well, as an accountant, I received my summons in January, so I had to reschedule. But the date arrived actually about a week ago, and I was still dreading it because I was tired from my busy season. But and we'll talk about it, more. But after serving, I will not have that feeling going forward.
That's great. And Ms. Bradford, did you say that this was your first time?
Yes, this was my first time, and when I received my summons, I was quite excited. I was looking forward to the process, and I did not research on how to get out of it at all.
Yes, Judge Hind.
I'm not up here because I'm a juror. I'm up here because I'm a judge. But I did get a summons and had jury service in March. And the way I found out about it was I got a text from my wife around the time the mail arrived that just said, "Bwah ha 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 ha." Whenever I get that text, I know I got my jury summons. So.
And for those of you who served for a second time or a third time, were you more willing? Were you excited to go, maybe? Mr. Rowe.
Yes. I served, I guess, 5 or 6 years ago, and it was a criminal. And so this here recently was civil. But I don't know. I don't know if I'm different than everybody else, but I kind of like to serve, like to be a part of it, and just exercise my right. And just like you have a right to vote, you have certain rights in this country, and I think that's just one of them. I think everybody should have that outlook on it and do their duty.
Ms. Sophie?
This was not my first time, but when I received my summons, I had to reschedule, and so it ended up on Valentine's Day. So everything was happening on that day, but It's okay. I was in Judge Hawkins' court, and she was just very professional, and everything went as she said. And I totally, walked away feeling very good, like I always have, because I've never, well, when I went to, what is it, for the traffic court, that was kind of a circus. But the others, no offense to anybody that's a judge out there, but anyway. Um, and I sincerely believe that it is something that we should all be anxious to participate in and serve as examples to the kids coming behind us, that it is important to vote. It's important to serve on such an important thing that has such an impact on the individual. And like any good lawyer will tell you, people say bad things about lawyers, but when you need one, you're happy to find a good one. So that's, I think the same thing goes with the jurors. If you need a jury of your peers, you want it to be out there. So I take it as an important thing.
Mr. Ver.
Likewise, this was my third time. And the other 2 times, I really have to admit that I would have kind of liked to have a way out because I was working, and life is much busier when one is working and raising a family. But I did serve each time I got mine, and I know people that just throw those summons in the trash can, and I don't really respect that. I feel like it is our duty and our privilege to be able to serve. And I always think that if someone I loved or myself was in that situation, I would want someone like me being a juror. So I did go. But this time I was retired, and I thought, okay, I'm doing it. So, and really, I left with positive feelings, and I felt like justice was served and that I helped that process along.
Fantastic. So I heard so many positive things, but we need improvement here. So what's wrong with it? What didn't you like? Ms. Bradford, I believe you mentioned you didn't like the assembly room.
Absolutely did not like the assembly room.
Okay, this was the specific thing you wrote down, that this was the least favorite part.
It was. The chairs were hard, and I felt like I was in a cattle room. There were so many people in there.
Okay.
And it was hot. It was just uncomfortable. And you just sat there, and people stepping over you, and maybe I'm just spoiled. I don't know. Maybe I feel entitled, but I wasn't comfortable where it was held. So.
Yes.
Were you in the normal space, or were you in the temporary?
The temporary.
That's my understanding, is that
The
there was
temporary,
as a
from the
result
flooding.
of the flooding, yes.
Exactly.
It's very very unfortunate.
And the drinks and the food were exorbitant.
And there were people standing.
Yes.
There were people that could not even sit in one of those uncomfortable chairs.
They
I was
were-
glad I had an uncomfortable chair.
It's great to hear, though, that people are still going, despite the flooding and despite the temporary arrangement. The court is moving forward with with jury trials. That's an important. Please.
For me, it was the parking.
The parking.
Because the garage by the courthouse gets full, and then you have to travel around. And I just think that if they were to give you a token at the end of your serving time, and you could go and just drop that in, if that parking garage by the courts was reserved for the jurors, or a section of it, and they would give you a little token once you're done, just go drop it in and off you go, instead of having to pay out of your own pocket, which I think it holds a lot of people back because they can't afford to go to jury duty.
Absolutely. Yes, please.
But I have to say, this third time, I took Park and Ride, and it was free. It was the greatest thing since sliced bread. And this morning, I took Park and Ride for the second time.
That's fantastic. So it sounds like there's a lot that can be done on the sort of creature comforts of respecting jurors who are arriving to the courthouse. But after you get past the assembly room and you move forward towards impaneling, I believe, Mr. Rojo, you thought that jury selection took too much time and was, I thought I wrote that down, and you thought that it took too much time, was a waste of time. Is that right?
Well, they brought us in there, and you're talking about when the lawyers ask
That's
questions.
right. Yes.
Okay.
So when you after you are pulled from the assembly room and you start going through the culling process, where the jury is going to be selected.
Okay. Yeah. Well, I mean, I understand the whole process. I mean, it takes time. There's pertinent questions that need to be asked and answered, and to weed out those biases. I understand all that, but I mean, I didn't think it was too lengthy. But I mean, I think it went well. I mean, I don't know if you can get any faster with it, or I mean, I think it lasted maybe 40 minutes or so.
Did the attorneys in your cases conduct the questioning process, or did the judge? The attorneys. did.
Attorneys.
Judge Hine, do you allow attorneys to conduct voir dire?
Yes.
And why do you? Why
Well-
don't you do it yourself? There's some disagreement amongst judges about which is better.
The state rules allow the lawyers to examine the veneer. I mean, the judge can too. So I ask the basic things. Do you know any of the lawyers? Do you know any of the parties? So that there's no awkward questions there. But the state rules require us to allow the lawyers to examine the panel, and that's what the lawyers expect to be able to do. So and one other thing, the lawyers know the case better than I do. They're going to know the issues that need to be addressed with the veneer. They'll have those questions prepared.
Of course, yes.
Judge Hine, do you ask questions or do you talk to the jury about the ideas of definition of the burden of proof, things like that? In my experience, when attorneys talk about it, they have varying degrees of success in describing what it is. I wonder if you give thoughts about that and whether the jurors understood, if they remember the discussion of the burden of proof, for example.
I usually wait for the lawyers to bring up burden of proof, and then if they define it accurately, I let it go. But very often, it is defined or analogized inaccurately, and I feel like I need to jump in at that point. And I use the PJC definition for preponderance of the evidence, and then move on. I do find that oftentimes, whether intentional or unintentional, the questioning from lawyers on burden of proof causes more confusion than it succeeds in ferrying out jurors who would understand the burden but would not apply it.
So for the jurors, in the case when the attorneys were questioning you, did you understand why they were asking certain questions? Did they ask something that seemed kind of strange, or that maybe was too personal, that you found off-putting, or did you kind of follow what they were getting at during the process? Did you feel that they were arguing the case, for instance? That's something that a big no-no. Any jurors? Yeah. Oh, I thought, Michelle, I thought you had something to say.
I think in the instance that I experienced last week, I felt like the plaintiff's attorney was actually arguing the case. And, we were instructed to, as much as possible, lay aside our biases and prejudices. And there was more of an emotional tone. And I'm like, okay, well, that's not really helping me, turn that off. But as well, even in the voir dire, I expected, I guess, more detailed questions. And there was just the generic, is there any reason why you feel like you couldn't, be impartial or serve on the jury, which was, I guess an out for a few people. And then based on that line of questioning, at that point, it just felt like we were selected, in sequential order. But I would have probably appreciated actually more detailed questions, trying to find out, maybe my personal or professional background would be a bias that I couldn't overcome, or would be more helpful to one side, as opposed to the other, where, the defense attorney would have said, hey, I want to strike her, and I would have been able to play golf that day because I planned. But that was my experience.
Do you think there was a question, without getting too specific, do you think they should have asked you a question that they did not, that you think would have gotten you tossed?
I think my background, based on the type of evidence that we had to examine, for the for the defense side, he might have said, okay, well maybe she does too much digging, and knows how to add numbers too well for, and so we would want to strike her. But it played out as it did, and so that's just something to think about, for the attorneys in that voir dire to not try the case, although it does give you a little bit of background about the case, but not to sway you in that direction that they're really that you've been instructed not to go. So that was my experience.
Did any of the other jurors feel strongly about the attorney questions about them being adequate or inadequate? Ms. Breck.
Yes. One of the things that the attorney for the plaintiffs, they suggested that we perhaps could have media coverage, and that prior to any selection, and that really kind of scared some of the potential jurors, and they didn't want any part of it, had no desire to have any part of it. And
Do
also,
you think in earnest, or were they saying that?
no, in earnest. And then secondly, it was interesting to see how the defense attorney would turn the questions back around. You knew exactly what he was doing. He's trying to requalify some that had been perhaps disqualified by the plaintiff. So it was very, very obvious.
Yes, Ms. Rivera.
I also felt like Mr. Rojo, that the voir dire took too long. I felt like they were repeating themselves all the time. One of the lawyers was very well prepared. She knew her questions, and the other lawyer, the plaintiff's lawyer, was not very prepared, and she was umming and ahhing and looking through papers, and there was a lot of time lost by her lack of being prepared.
Did that bleed over into your, I don't want to jump far too ahead, but I'm curious, did that bleed over into your later assessment of the case and their presentations? Even at the beginning during jury selection, did the attorney's presence, either being aggressive or ill-prepared, I'm not saying you didn't judge the case
I felt sorry for the plaintiff because I felt like the plaintiff's lawyer didn't do a good enough job, is what I felt like. But in view of I don't know that the outcome would have been different, but definitely there was a lot of difference between the way that each lawyer presented themselves. And I do feel like that played into it.
Mr. Rojo.
Yeah, just on the flip side of that, I think that one of the lawyers did a very good job of, and I won't go into any details, but he gave an example of a situation where, similar to the case, and what if it was this your family member or this happened to you, how would you perceive that, or how would there be any biases? And so you need to, he basically said you need to look at the situation, and doesn't matter what the circumstance is of the person, of the plaintiff here, and what their background or education is, or their communication skills. Look at it for what it's worth. So he kind of positioned that basically a theme there that to kind of outcast any biases. So I thought that was real good.
Yes.
I agree with him. I agree with this young man, Mr. Rojo, because it was the same situation with the two attorneys. The plaintiff's attorney, even though I thought he had a decent case, I don't think he really went into it as deeply as the defendant's attorney. The defendant, he was representing a well-known company in the Houston area, and he just rolled it out like, red carpet. I mean, you couldn't say, you was like, yeah, that's right. But then when the plaintiff, even though he had a similar situation, I think he should have done a little bit more research into how he was going to present it. And like he said, he should have brought out issues like, if this was your family, how would you feel? Or how would you feel if that was your mother or your father or your sister, your brother? Even though you're looking at it, you're trying to look at it like I need to make a good decision here and I need to make the best decision. But you shouldn't, would you do that if that was your relative? So even though the defendant young man, you could tell that he was very well versed in what he was doing, I still think the plaintiff could have done a better job if he had found a good way of presenting, to get our attention.
One of the innovations that the Civil Jury Project has been studying and that certain jurisdictions are starting to use, and it's a way of speeding up voir dire and to get sort of a lot of answers up front, is the use of long-form questionnaires. Did any of you fill out maybe short-form questionnaires here? Anything at all? Just simple stuff, your name, your occupation. Some of you did, but there was nothing more in-depth than that. Do you think that that would have been a more efficient use of your time to say, oh, instead of me needing to go down, you know, the whole voir dire process, if I could answer just some of the stuff up front so we could get through people more quickly? Do you think that would have been useful? I'm sorry, I thought Mr. Rojo, you had something. No.
I think the more information, the better. Maybe that will cut down on some time.
Judge Hind, have any attorneys ever approached you asking to use or administer long-form questionnaires, more substantive questionnaires up front prior to voir dire?
Yes,
And have you allowed them to use it?
in one case.
Why in that one case?
In that one case, it was going to be a 6-week trial, and we were already undertaking a lot of extraordinary procedures for it, increased juror pay, paying them weekly, and so forth. And I didn't want to get 4 weeks into the trial and lose my 5th juror and then be down to under 12. I'm always hesitant, to be quite frank, of doing it because of the logistics involved. Mindful that jury service can be an inconvenience to our citizens, I try to make sure that we always complete jury selection in one day. When you start adding in the questionnaires, you've got to account for the logistics of distributing them, filling them out, collecting them, distributing copies of the answered questionnaires to the various parties. This was a case with probably half a dozen lawyers. So in that case, the parties had the means and the cooperation from the Houston Bar Association, to be quite honest, to place a photocopier in the HBA room in the courthouse so that they could quickly take the questionnaires over there, make all the copies that needed to be made, distribute them, and so forth. But it's hard to see how you can do a questionnaire and get meaningful use out of it and still seat your trial jury in one day. So those are some of my reasons.
So it may not be the time saved that it might initially at first glance look like.
Right.
Right. So after the jury selection completed and you guys sat down for the trial to start, the attorneys gave opening statements. At this time, you're not supposed to be arguing your case. Well, my apologies. What did you guys think of opening statements? Did you guys think that they influenced your, like right out the back? Did it win the case right off the bat, or were you able to say, oh wait, I kind of am now understanding what the dispute is here? Prior to getting in the room, prior to the trial starting, I didn't quite understand what the case was about. Now I'm starting to understand it. Or alternatively, some attorneys are under the belief that opening statement is how you win your case. So what were your thoughts on opening statement? How did the attorneys do? I mean, perhaps Ms. Sobey, you said that the attorneys weren't as well, one of the attorneys wasn't as well prepared. By opening statement, was that preparation more visible?
No, it seemed that the other lawyer the plaintiff lawyer was very prepared, but the other was not. And it wasn't until the last day, or the second day, that another one appeared that seemed to be really with it. So I don't know what the deal was, but
Could you describe, I'm sure some of the attorneys here would like to know the difference between the two, like just a little bit more description about what lack of preparation looks like versus what, quote, with it looks like.
Well, for example, the plaintiff, her lawyer he didn't have to look and see the questions, and the other guy, it seemed like he just didn't know all about the case. And so every time it was his turn, he would just have to go through and look through the papers and all this, which really affected all the jurors. And that was the first thing they said. The other guy was so unprepared. And even though you're trying to keep an open mind and be fair to both parties, even when the lawyer for the defendant was questioning his own client, he still was kind of lost for questions, and it was very obvious to the jury that he wasn't as prepared as he should have been.
Right. do any of the other jurors feel the same way about preparation and productive opening statements versus perhaps not as productive?
So as far as the opening statements, the plaintiff's lawyer continued a little bit, with the emotional side of things. I'm like, okay, I'm getting ready for a soap opera, which I don't watch. But I just felt like it was more or less not meeting the jury where they were. And I mean that by just using good professional English and not, the lay, hey, we're out on the street, And so it was just hard to follow when you're not used to speaking that or hearing that. It was hard to say, okay, well, if, you have the preponderance of evidence, I'm trying to listen to you so you can get your 51%, he made it somewhat difficult. And so, but, throughout the process, it's like, okay, let's keep an open mind, because of course you think about if I was on that side, it'd be difficult. It's not a particularly easy job to be an attorney, but I just felt like in the opening statements, I would have preferred the plaintiff because this is your opportunity. This is why it's you that called us here. And I feel like from the plaintiff side, you really have to take advantage of that time that you have. And that preparation is a form of respect. And, if I'm doing this and taking my time, we feel like we deserve that respect so that, by word of mouth, hey, if you get that summons, you need to go. And it's, I think going forward, it's that word of mouth where we share with our peers and we share with our, circle of influence. Hey, if you get a summons, it's important that you go because a right is only important to you until there's a threat of it being taken away.
Absolutely.
So.
Absolutely. That's very well put. Right. Mr. Mann, yes.
I agree too. For the defendant, he represented, like I said, a well-known company in the Houston area, and he started his defense when he was interviewing us as to jury selection. He brought out the points that was important, and he did a very good job. And I think if the plaintiff attorney had done the same thing, even though we may have came to a similar decision, it would have been a lot harder, and we would have thought about it a lot longer. I think he would have had a better case if he had started his defense with the jury selection like the defendant's attorney did.
So it sounds like opening statement did make an important impression on you guys. I wanted to ask you something, Michelle. You said that the attorney kept making emotional appeals. This is something you wrote down earlier as well.
Yes.
Do you think that it sounds like it wasn't effective on you, these emotional appeals, but some attorneys think that when they're dealing with jurors, they need to appeal to their emotional sense. It seems off-putting. It seemed to have off-put you.
I think it is because, again, we're instructed that although it's natural to have biases and prejudices, those are, often triggered by emotions. If I'm angry about something, I may feel, and depending on what that topic is on that particular day, I'm like, no. And the next day, if I'm happy about it, emotions are fleeting. And if I am to examine evidence, I can't do so, by having this emotional, undertone. And I think, too, my background, like I said, being an accountant, it's just, hey, these are the facts. You try to stay away from the gray areas. And so just as an individual, I think it was very off-putting for me to say, okay, well, don't rely on your biases or your prejudices, but hey, shed a tear. My client is now crying.
Do you feel that the other jurors on your case, do you think they were more swayed by the emotional appeal and the crying client?
Surprisingly, yes. I found that there was a more male. It was more majority male, and the plaintiff in the case was a young lady, and I found that the men were actually, and I don't want this to be construed the wrong way, but the men were actually more, welcoming of the emotion. I'm like, dude, get it together. So, but it was all in balance, and I tried to say, okay, well, this is what you're going to have to deal with, obviously throughout this process. So, just try to walk that line of, impartiality as much as possible.
Yes, Ms. Rivera.
Likewise, we had a predominantly male jury, and it was a young woman who it was a personal injury suit. And the men they really played into her "for me" thing. Luckily, the women kept the balance. But for myself, I'm a retired nurse, and I really thought I'd be disqualified from both ends because I had a bad experience with the insurance company, and I am very scrutinizing of personal injury complaints because a large part of my career was spent managing work injury cases. So I can read through a lot, I think. Anyway, I found it difficult because we were told to make our decision and that we couldn't bring in like things that we knew from elsewhere. And I felt like the lawyer for the insurance company should have had an expert witness, or I don't know if you cannot refer to studies and statistics, and if you're not able to bring that into a courtroom. But I felt like that would have put things into perspective that, many people have certain types of injuries and yet have no symptoms, and this is well documented in the past. But the people in the jury were continuing to say, but she's complaining of this and she's complaining of that, and I didn't feel like I could bring up what I knew because it hadn't been presented as evidence in the courtroom. And I asked the lawyer afterwards why they didn't do that, and she said, well, it was very expensive to have an expert witness, and I said, well, yeah, but you could have told us about studies, you could have flashed it on that board, everyone could have seen. 30% of people. Anyway, that was just my observation. And in regard to the two lawyers, for me, I tried to squash that and not let it, influence me so much. But one of the lawyers was very polished, very well dressed, very clear, very articulate, and the other lawyer was professional looking, but not as polished. Her way of delivering everything that she said was less polished, which gave you more of an impression that she wasn't as sure about it. It wasn't as convincing, and I didn't want that to be an influencing character on me. Right. But I think nonetheless, it did. I think that her presentation, both in appearance and demeanor, and the fact that she was more prepared, her delivery was much more convincing.
Absolutely. Ms. Bradford, it looked like you had something to say.
I do.
Yes.
The attorneys that we had, well, first of all, the case was a product liability / fatality. So it could have been a very tough case. And I understand.
Case, if I remember correctly, this case settled before you guys.
Yes, it settled before we ever actually finished the first expert witness.
Gotcha.
The thing about it is it's all strategy. This is my opinion as to how the attorneys present their case. Obviously, the plaintiff is going to be emotionally, he's going to pull on your heartstrings and approach the case from that point. Where on the product side, they're going to be like type A personality, and they're just going to roll everything out, boom, 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 and it's going to be succinct and it's going to be very well presented versus the emotional side. And in order to put those two things into context and understand without it swaying you, is tough, but it's doable. And I think that's, I don't think that the opening comments swayed one way or another any of our jurors. We were, I'd say, 75% female, 25% male, and I'd say we were probably all over. There may have been 2 or 3 that were under 35. Most of us were older.
Interesting.
And so it was interesting the way that they approached the case, and there were multiple attorneys in there. and doing the presentation, and they each were given, they used every minute of their allotted time.
Interesting. Moving forward to as the trial kept moving on, Mr. Rojo, you wrote something down that I would have asked everybody anyways, but you raised it. You said that you wish you could have asked questions during the trial. This is something that I want to ask everybody if they wish they could have asked questions during the trial. But Mr. Rojo, I'd like to start with you, since you said this is what you wrote down as what you wish would have been different.
Right. I think everybody would like to ask questions. Speak for everybody here, but yeah, I mean, I understand the process, and you start thinking about the case and how it's going along, and questions pop up. You just well, how did this happen? What happened before this happened? And can I see some exhibits or what? Where are they at? So you have all these things that come up, and questions come up, and the process is you just got to hold back until the end, and then you can ask your questions. I think you can submit questions to the judge.
Even if they allotted like an hour at the end of the day, where it's just the judge, the attorneys. And
Typically, the way that it's conducted in those courts that do it is after a witness testifies, the jurors are all allowed to submit a question. Everyone passes forward a single card, whether or not they wrote on it. It goes up to the judge, and then the judge will ask the attorneys if there are any objections, and then move forward with it. That's in those jurisdictions that practice it. Judge Hein, have you ever allowed jurors to ask questions in your courtroom?
No, I haven't yet. A few years ago, we were trying to do a study through U of H of several jury trial innovations, and questions from the jury was one of them. And I participated in that and would always offer a docket call. Who wants to do one of these jury innovations? And not a single case out of 2 years did any lawyer express an interest in trying any of the innovations, even the ones that I really tried to push, like pretrial instructions on legal definitions and so forth. And so, part of it is, judges are former lawyers, so we're not going to try something if the lawyers aren't going to buy into it. And so part of it is we need lawyers, and y'all need to talk to each other, your opposing counsel, and come to the court, say, hey, would you be interested in letting us try this, both sides? That would be powerful with me. I'm one of 85 trial judges, so it may not be powerful with another one, or there may be other judges who want to just impose it on your case whether you want it or not. But I think part of this is having lawyers get together beforehand, talk to each other, and see if you want to try some of these innovations.
Would you ever raise them in something like pretrial conferencing? Just say, hey, here are some ideas. If you guys are open to them, go confer and let me know. Rather than, so raise it to them, but not force them to. Just during pretrial conference, here are innovations that are popular in Arizona. They're very well used. In Denver, they're well used. We don't do them here, but maybe you'd be interested. Would you ever do that?
I imposed time limits for several years. I did.
You did.
And then a lawyer who I respect made an impassioned plea to me not to do it anymore. And I told her, I'll try it for 6 months, but if I start having cases going over time, then I'm going to do it back. I only had one case in that 6-month period exceed the allotted time. So what I've done is kind of a compromise. I set time limits on voir dire and opening statements, and usually by the end of trial, that gets the lawyers into the habit of moving quickly and efficiently, so I don't need to impose time limits on witnesses or closing arguments. I did have to do it in one case where the first witness took 4 days. And so I told the lawyers, okay, I'm putting you on a clock. But the answer to your question is I did try and impose time limits, but I also think it's important for us to listen to the bar and get the lawyers' feedback as well.
Absolutely. That's the bench, the bar, but also the jurors, and that's why we have them here. It seems like you guys, moving to some of the others, you said you do wish you could have asked questions of the witnesses. Is that sort of across the board? Yes.
I would just like to say that I think it would be a good thing if you could ask those questions, but at the same time, it's going to take up more court time, and maybe you're going to ask questions that that person should not answer in order for you to keep a fair jury.
Yeah.
And so is it really going to save time if it's going to be a conflict, since we don't know the laws like the lawyers do?
Absolutely. One of the hopes is that through your questions, you do elucidate sort of for the attorneys what you guys are thinking a little bit, and they may tend to less towards repetition of things you don't need repetition on, and maybe answer questions that you have remaining that it's difficult for them to know. There are some issues with even that practice, but it is common in certain jurisdictions, and in a lot of cases, most states, I believe, it's allowed if the judges agree. In civil cases, in criminal cases, it's different just because of constitutional implications. Yes, sir. Of course.
When I preside over a case in the federal district court, I have the jurors ask questions in civil cases, and typically the lawyers, it's the first time this has ever been done, because it's not that common in Houston, but without fail, the lawyers after the trial said they liked it.
They did.
Not even so much, sometimes the questions are really useful and get testimony, sometimes just like lawyers' questions, sometimes they're not so useful, but the lawyers really liked it more than anything because it told them what the jury was thinking about, what the jury was confused about, so when the next witness came up, the lawyers knew where they needed to do more work.
Absolutely.
That was the benefit of it, more than the actual question, the answer to the question elicited from the witness.
I have no idea how to use this.
gosh.
Maybe it works. Does it work?
Yeah, I would agree with that. We've done it a bunch of times. I only do it if the lawyers agree.
Yeah.
In my experience, that oftentimes I think it's had a couple of effects. One, that it makes the lawyers realize what we see every day as judges, that jurors get things a lot quicker than as lawyers, and you're paranoid as a lawyer that you're not making your point. Not that you don't think the jurors are smart, but you're just worried about your case. And I think it lets the lawyers see, wow, the jury's really getting it. In fact, sometimes they're asking questions that are 2 or 3 questions ahead. Yeah. Sometimes they say, could you tell Mr. Smith to move it along? Well, I think if I'm Mr. Smith, I'd rather hear that now than at the end of the trial. And here is what I think has been people's experience who've done it that's really helpful. If you let the jurors ask questions, so assuming you do it in a way that's very efficient, it virtually eliminates the questions they asked during deliberations when we cannot answer them. And that has been something that we have seen as a good effect of juror questions.
I'm glad you brought up deliberations because that's actually what I wanted to move to next. I know that some of you were not able to deliberate because the case settled early, but for those of the jurors that did deliberate, when you were sent back to the deliberation room, you were given instructions. Did you think that those instructions were helpful? Was it just gobbledygook? Was it legalese that was just impenetrable? Did you guys understand the task that was before you, is what I'm trying to ask. Ms. Sobi, could you mark on that?
Well, our judge explained everything to us, and then we went into the room, and there's so many different opinions about everything, but right off the bat, we said, okay, how many feel in favor of this? And let's just get right down to it. And so that's what we did. And then from that point on, one gentleman started putting on the board, how we were feeling about this and what about this. And so it moved the whole deliberation thing right along by making a chart as to what we needed to address and how the voting was going. And then we even compromised on some of the issues because, some felt real strong about this, and we said, okay, well, if you do this, we'll vote with you on that to get a unanimous vote. And we walked away with a unanimous vote on everything. So.
Absolutely. No. Alexis de Tocqueville, I know I bored you all with the history earlier, but Alexis de Tocqueville, a French sociologist who came to the United States and studied the juries, described the jury as a gratuitous public school that instills some of the judicial habits into every mind, and that without that, no political virtue could exist. It's through that process of deliberations and through engaging with your peers that we come to emboldened to make decisions. Did anybody else feel that way? Those that were able to deliberate? Okay. Ms. Domain.
Well, it was kind of opposite of what she said in our group. There were some questions that we wanted to ask, but at that point we couldn't ask them. We wrote them down, and then we sent the lady that we had selected for the head jury person to give the questions to the judge, and she said no, that at that point we couldn't ask questions. So I think earlier, if we had been able to ask some questions, it could have cleared some things up.
Mr. Vera.
Same with us. But the instructions that we got before we went into deliberation were very clear. We knew exactly what we had to do, and it made it very easy. We did send a question back, and of course, we didn't get an answer. So we just had to do the best we could with what we had.
Yes, Judge.
I want to do a little experiment for a second. Because I want to use, I don't think I did it. I want to talk about the dreaded I word, insurance. We always, as judges, we are taught, and as lawyers, we are scolded to take great pains not to inject the idea of insurance into a case. Well, first of all, was that your experience? That did the word insurance come up, and did someone did the judge quickly quell that, or was it brought? Did someone did people start whispering or muttering or expressing concern about that? And then, if you had known, I know some of you didn't get to it, but if you had known that one side or the other did in fact have insurance that would have covered the claim that was being made against them, would that have made a difference in the way you looked at the case? Either way. And if, would you have liked to have known that? And what would you, and how would that affect your
Objection, compound question.
I was about to say yes, 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 maybe yes.
I actually have
Yeah, please.
I can respond to that because our case did involve insurance. And we were instructed multiple times not to consider insurance. And as we were deliberating, a few people, and actually, one person ended up just abstaining from the vote because they couldn't get comfortable and they couldn't get confirmation or denial of that. So,
insurance was a car wreck case.
correct. It was a car wreck case. It was a car wreck case, and because of the monetary damages that were, being requested, and if I can step back just for a moment, when we were given the kind of the initial overview of the case, we were told, we'd be evaluating like 3 types of monetary damages, and when we received the charge, there were 11 different lines, and I'm like, well, okay, now I have to kind of think through this breakdown. And so that's when the insurance concept was brought up, and we were like, okay, well, no, we can't think about it. And we were like, okay, what if this person had bodily injury that would cover that, And it's like, well, you can't think about that. And we were instructed not to discuss it, but I can certainly say that if we were allowed to consider that and question that it would have had an impact on the final damages that were awarded.
Can you elaborate now?
Well, I think because again, if I can give a direction, it would have lowered the damages because we would have said, okay, well, this person, these damages have already been covered, they've already been paid. So are we now just giving this person a yes,
That's why you guys aren't allowed
extra
to hear about it.
zeros? Yeah, I was like, that's why y'all shouldn't have picked me to be on this.
What you're saying, I'm not
No.
I find that you surmised, and I'm not being critical, I just really want to know what you're saying. You surmised that if you had known there was insurance, that would have meant in your mind that insurance did already pay for some of the damages, and therefore, as jurors, even though you heard nothing about, you surmised that it was already paid, and therefore, as jurors, you wouldn't have rewarded any amount because you assumed that it had previously been paid.
Well, in taking into account the expanded type of damages that we had to consider, it was past and up to a point and in future, it would have impacted the future damages. The insurance that paid or may not have paid, in the past, I think for us it would have impacted, okay, well, what money would be awarded for future loss or things of that nature to avoid that double dipping. Is that amount, if that amount was already covered or paid by insurance, then why would we give this amount for future coverage where you will continue to be insured going forward? And so that would have been the impact to that question.
All right, last follow-up. If you had received a specific instruction, we do give you an instruction to do not consider the effect or whatever that insurance coverage of any kind. If you had gotten a specific instruction that specifically no insurance has been paid in this case, if it exists at all, to anyone whatsoever, period, the end. Can you tell us how would you factor that in?
I think then it would be your number starts at 0. So any amount that you would award from that point would, remunerate that person for any lost wages, any damages, any impairments. And I think I need legal representation because I feel like you're I'm just messing with you. But I think that would have, kind of influence what that starting number would be and which direction you go, up or down or otherwise.
Well, this is such a great discussion, but I'm afraid we're going to have to wrap things up. If you guys have any questions for the jurors afterwards, if they could ask you, if they don't, you don't have to talk to them, just like after the case. But if we can give them a round of applause, please, that'd be great.